Okay, so we'll keep things moving along. So we just want to talk about a project that we started back in February. Unofficially started in February. There's a little bit of a story to that. We were lucky enough, mad enough to put in a bid with ASSE for funding. We got told about it very last minute. It was happening at breakneck speed. And the reason it was happening at breakneck speed was because the UK government were meant to be on track to sign a document in France, in Paris, and then at the last minute, the Americans told them not to sign it. So they had all these projects already ready to launch. They had 20 of them. Ours was the only one in law, which is upsetting. But it was probably a little bit mental as well. So we had only opened the centre, about 2 months before that. And so we sort of thought, well, look, we'll use it as an opportunity for the group to try to work together to put a bid in, and we'll treat it like that. And so that's what we did. 3 or 4 of us got together. We thought, right, I come from a practice background as a barrister. So one of the areas that I had sort of looked at and often thought, how would you get AI into the courts? How do you do that to make a tangible difference? And an area that I kept hearing senior counsel talking about was the use of early neutral evaluation in the commercial courts here in London. So naturally enough, we started work on that, and I thought that's the one area that AI could do a much better job, because it can take on masses of information, whereas a human judge who's trying to hear that in limited circumstances, so it's going to struggle, because they've only got a few hours to have written and oral argument put before them. So we put together the project, and we're very, very surprised to hear back from ASSE that we were shortlisted, and then even more surprised to hear that we'd been picked. And then the team got round to thinking about, right, how are we actually going to do this, or how are we going to deliver this? Because we haven't had the opportunity to warm up the courts. We haven't the opportunity to warm up the Ministry of Justice. We hadn't even got the chance really to properly warm up our colleagues, an AI professor and some colleagues in the School of Computing and Intelligent Design. So yeah, that's how this project came about in the first instance. We did hit some speed bumps very early on. The worst of all was writing to the Master of the Rolls, begging for access to these early neutral evaluations, only to wait for a few weeks to get a response back. What early neutral evaluations? We've only had 4 of them in the last 5 years. So at that point, we had to pivot, and we needed to find a data set to support the research that we're doing. So, spoiler alert, we did find the data set. We're working with it at the moment, but maybe we could just talk a little bit, and maybe John, you want to have a talk to us a little bit more about what is it that the project's hoping to achieve?
So thanks, John. So when we looked across and did some surveillance in relation to the deployment of frontier generative AI and agentic AI within courts generally, we were looking primarily at the evolution from predictive analytics right through to how generative AI was actually being used and deployed in courtrooms. And of course, it comes as no surprise that many of the drivers for that are the efficiency gains and the pressures of the backlogs of cases that one sees in the modern justice system. But on the other side of the coin, of course, we have the ringing in your ears, the problem of oversight, alignment, control. And these issues which really present societal risks to the actual deployment of generative AI within a judicial and indeed in a courtroom setting. We did pause and note that we're not the first in relation to the use of AI within judicial assistance or the assistance of judicial decision making, but we are the first, we believe, that have argued for the deployment of agentic AI within a judicial setting. When we looked at our intelligence and our surveillance, we noted that judicial systems vary considerably globally. There's very modern contexts across, for example, Singapore and China, where they're using, at pace, one should say, the deployment of generative AI in assisting judges in making decisions. And then we come to other jurisdictions. France is a very good one, who are inherently risk averse. In fact, they have legislated to prohibit predictive analytics even in relation to judgments in their courts. We also noted that practitioners, formally and indeed, more importantly, informally, and indeed judiciary, are actually already using generative AI. Now, that brings a number of fundamental questions: how safe it is, what the system they're using, is there data confidentiality, is there data security? So these were things that we found, and we noted a UNESCO survey, for example, of one bedrock of evidence showing that there was informal use across judicial members, or from the bench, and indeed from practitioners. So in this project, with all these warnings and concerns, and particularly looking at this from an alignment and control perspective, we noted the need to take real caution and approach this, the balance of and the opportunity that this presents with the risks and in relation to the innovation.
Yeah, and I think one of the projects that we have been in touch with was one in Brazil, which some of you might be aware of. Brazil has a rather acute problem of a backlog of 80 million cases. So they have worked there with a couple of different AI pilots, not to make the decision itself, but to get cases ready for the judge to make the decision, particularly in binary type decisions where an element of documentation needs to be provided by one of the parties so as for a decision to be made. And so there was a Victor project there, which has been used and quite successfully to try and speed up the process of making judicial decisions.
Yes, and another good example of that would be the IBM project in Germany, where again they approached it in the same way, in that they, for example, the emissions scandal, they employed a very good system actually that IBM built, which allowed judges to ready cases and move cases along, and indeed actually assist with some of the decision making in relation to the case. So in relation to the project itself, and covered the ground already, but we did note that quite a lot of the existing use was an application of single agent based approach. And in this context, we have decided to try and employ an agentic AI approach, which will allow for, as Samuel talked about earlier, better application in relation to how agents work, better RAG, and to ultimately to try and improve the outcomes and the explainability and the efficiency of the process. And again, touching upon what Ronan has already talked about, and indeed Samuel has identified, this allure of reasoning in courts, that this is we're arguably trying to look at the white box of the black box in this respect. But one of the things that we were particularly interested in this project is that reasoning aspect. What approach can we take? What protocols can we employ where we embed both cognitive science with lawyering to actually inform the reasoning approach that a system will take? And indeed, some of our intelligent systems analysts and our computer science analysts that are involved in this project with us are looking at how we can actually back end the deployment of the LLM on a feedback look to try and reduce hallucination bias. A further thing that we are trying to do in that respect as well is looking at the corpus of how, not just the RAG, but the corpus of the body of evidence that we use, and indeed how that is deployed within the system.
Do we want to touch on the data set at this point, or are you?
Yeah.
Yeah. So I touched on the fact that we struggled when being told that there was 4 cases. That is not a data set that you can reliably use. And fortuitously, as we learned that, we were back in London for a different conference and bumped into an old friend of mine who we had breakfast with, who is the managing director of an arbitration service here in London. And I was telling him about this problem, and he looked at me and he says, well, no, I don't think that's a big problem. He says, we have 4,000 decisions. including the bundles of arguments. He says all the data is there. Now we'd have to think about GDPR, but the data set exists. So this is quite a unique data set. As many of you will know, arbitration decisions are not published, generally speaking anyway. They're a private form of law, if you like. So we were delighted to get this discussion underway. And we have found a way, which again, some of you researching in this area will be very familiar with, which is to use the data set to produce a synthetic set of data, which then sidesteps the issues around GDPR. The arbitration company will provide the synthetic data for us, and then we will be able to use that to train the model. Yeah, so I think that's really it around the data set.
Yeah, so that brings us neatly then back to our empirical evidence and evaluation. What we do know is that we don't know enough about the deployment of AI within the judicial setting. We fortunate enough that we are nudging along some of our intelligence with our senior judiciary in the United Kingdom, and we do know that they do have an AI tool and they use Copilot, and some might use that for case summarization and some might not. But it brings us back to, well, how are they using it, and what can we do? We can use it for retrieval. We can use it to actually assist them with writing a judgment in the correct style of the court that they are in. But what we are looking at with this is trying to bring more empirical insight into how this process works, how the agentic AI agent could potentially improve efficiency and explainability, and bring forward more empirical evidence to add to the state of the art. Now, on the flip side of this, we also consider that this process might be transferable to litigants in person, for example, at the other end of the scale, and how you could deploy an agentic AI tool in that setting as well.
Yeah, so I suppose even if we get there, we're told by our computer colleagues that we are getting there and we should be there with a reasoned decision maker, a transparent, reasoned decision maker that's trustworthy. But even if we do establish that, I suppose there's much larger questions. So we're aware that it needs to be done in a secure fashion, safety in mind. But the bigger question perhaps is ethics as well. So to what extent are we happy with this type of a tool being developed, that it is actually capable of making a reasoned, transparent decision? Probably a broader question for consideration as well. So even if we can do it, is it ethical to use it? Is it secure? Is it safe? Will it garner trust from the public? And that's kind of an interesting one, because if it was a decision around whether or not your house is going to be repossessed, you probably are not going to be happy with an AI judge. You're going to feel a little bit insecure about that. But if it was a parking violation, would you be happy with an AI judge? If you're stuck in Brazil and your case is 80 million and one, and it's quite binary in nature, would you be happy to take a decision today in the next 10 minutes? Or would you prefer to wait for the human judge? And that could be 15, 20 years away. Which, and again, raises bigger questions around access to justice as well. What is access to justice? What are we using technology for? Is technology just being created for the sake of creating technology, or is it trying to solve the problem? So there's a lot of bigger questions, I suppose, that come out of the back end of the research, we think.
And in one aspect that we think is quite intelligent in the reasoning piece is to employ perhaps like a blockchain to allow the human in the loop that oversight to see how the reasoning has happened in relation to a particular decision, where the information has come from on that closed loop of reliable, valid legal data. And with that in mind, we have a number of key outputs from the project, stemming from an MVP in relation to a product that our judiciary, we hope, will pilot and test, through to integration of ethical guidelines, and some simulations and that for our senior judiciary. So that is our presentation complete. Thank you very much. And if anyone has any questions, please direct them